Donald Trump's lawyers argued to the United States Supreme Court earlier in the day that Donald Trump could steal nuclear secrets and sell them, that Donald Trump could launch a coup against the United States, that Donald Trump could accept bribes from foreign officials, and that Donald Trump could order the military to assassinate his political rivals. Donald Trump's lawyers were making that argument in the United States Supreme Court. Folks, I never thought, as someone living in the United States of America, that it would get to this. The very fact that those arguments are being made before the United States Supreme Court by a former president, by the Republican leader, this is a travesty. And don't take my word for it. Let me show you the key moments during the oral argument. I'm only going to break it down so you can just see the key moments from this oral argument where Donald Trump was arguing for absolute presidential immunity for his conduct in trying to overthrow the results of the 2020 election after losing in the lower courts. Trump lost in December before a federal court in Washington, D.C. Trump appealed it to the next level court, which is the D.C. Circuit Court of Appeals, a 3-0 decision against Donald Trump, including from a conservative judge ruling against Donald Trump. Trump then appealed that to the United States Supreme Court. Here, during the oral arguments, Justice Sotomayor asked Donald Trump's lawyer, "Is it plausible to you that creating a fraudulent electoral slate would constitute an official act that you could have immunity for?" Play the clip.
Apply it to the allegations here. What is plausible about the president assisting in creating a fraudulent slate of electoral candidates? Assuming you accept the facts of the complaint on their face, is that plausible that that would be within his right to do?
Absolutely, Your Honor. We have the historical precedent we cited in the lower courts of President Grant sending federal troops to Louisiana and Mississippi in 1876 to make sure that the Republican electors got certified in those two cases, which delivered the election to Rutherford B. Hayes. The notion that it's completely implausible, I think, just can't be supported based on the face of this indictment or even
knowing that the slate is fake. Knowing that the slate is fake, that they weren't actually elected, that they weren't certified by the state. He knows all those things.
The indictment itself alleges, I dispute that characterization. The indictment affixes the word label to the so-called fraudulent electors. It affixes the word fraudulent, but that's a complete mischaracterization. On the face of the indictment, it appears that there was no deceit about who had emerged from the relevant state conventions, and this was being done as an alternative basis. But I want to...
Next up, Justice Kagan asks Donald Trump's lawyer, John Sauer, what about if a president orders the military to stage a coup? Is that an official act for which a president should receive immunity? Play the clip.
How about if a president orders the military to stage a coup?
I think that, as the Chief Justice pointed out earlier, where there is a whole series of, sort of guidelines against that, so to speak, like the UCMJ prohibits the military from following a plainly unlawful act. If one adopted Justice Alito's test, that would fall outside. Now, if one adopts, for example, the Fitzgerald test that we advanced, that may well be an official act, and he would have to be, as I'll say in response to all these kinds of hypotheticals, has to be impeached and convicted before he can be criminally prosecuted. But I emphasize to the court that—
Well, he's gone. Let's say this president who ordered the military to stage a coup. He's no longer president. He wasn't impeached. He couldn't be impeached. But he ordered the military to stage a coup, and you're saying that's an official act.
I think it would depend.
That's immune.
I think it would depend on the circumstances whether it was an official act. If it were an official act, again, he would have to be impeached.
Well, what does that mean, depend on the circumstances? He was the president. He is the commander-in-chief. He talks to his generals all the time, and he told the generals, I don't feel like leaving office. I want to stage a coup. Is that immune?
If it's an official act, there needs to be impeachment and conviction beforehand, because the framers viewed that kind of
If it's an official act, is it an official act?
If it's an official act, it's impeachment.
Is it an official act?
On the way you've described that hypothetical, it could well be. I just don't know. You'd have to, again, it's a fact-specific, context-specific determination.
That answer sounds to me as though it's like, yeah, under my test, it's an official act, but that sure sounds bad, doesn't it?
Well, it certainly sounds very bad, and that's why the framers have a whole series of structural checks that have successfully, for the last 234 years, prevented that very kind of extreme hypothetical. And
next up, Justice Kagan says, well, what if a president sells nuclear secrets? You're Donald Trump's lawyer. Do you believe that selling nuclear secrets to a foreign adversary, do you get immunity for that? Is that the position that Donald Trump is taking right now before the United States Supreme Court? Play the clip.
If a president sells nuclear secrets to a foreign adversary, is that immune?
that sounds like, similar to the bribery example, likely not immune. Now, if it's structured as an official act, he would have to be impeached and convicted first before.
What does that mean if it's structured as an official act?
Well, I don't know in the hypothetical whether or not that would be an official act. You'd probably have to have more details to apply the Blazing Game analysis or even the Fitzgerald analysis that we've been talking about.
What about if a president decides to use the military to assassinate political rivals? Are you saying that that is allowed? Are you saying that presidents should get absolute presidential immunity for that? Is that Donald Trump's argument? Is that what you are asking us to hold today as the United States Supreme Court? Play the clip.
Can be alleged, but it has to be proven. Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamentally evil that they have to be protected against. Now, I think, and your answer below, I'm going to give you a chance to say if you stay by it. If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
It could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an unlawful.
No, because immunity says even if you did it for personal gain, we won't hold you responsible. How could that be?
That's an extremely strong doctrine in this court's case law in cases like Fitzgerald.
Well, we
Harlan,
go back
Johnson,
to Justice Thomas's question, which
Okay, there's nothing worse than light pouring in the house when you're trying to catch up on some rest. And having good blinds in your home may just be the most underrated addition that you could make. There's a better way to buy blinds and window treatments, and it's called 3-Day Blinds. They are the leading manufacturer of custom window treatments in the US, and right now they are running a buy one, get one 50% off deal. We could shop for almost anything at home. Why not shop for blinds at home too? 3-Day Blinds has local professionally trained design consultants who have an average of 10 plus years of experience that provide expert guidance on the right blinds for you in the comfort of your home. Just set up an appointment and you'll get a free, no obligation quote the same day. Not very handy, the expert team at 3-Day Blinds handles all the heavy lifting. They design, measure, install, so you could sit back, relax, and leave it to the pros. I've been using 3-Day Blinds since way before they were even a sponsor of the MeidasTouch podcast. My friend had redone his entire home with 3-Day Blinds. He got the smart blinds installed where you just ask Alexa to open your blinds and it happens automatically. I thought it was the coolest thing ever. I asked him, where did he get this? How did this happen? He told me all about 3-Day Blinds and how easy the process was. And I ended up getting all the blinds in my home from 3-Day Blinds, and I am so glad that I did. They had so many options to choose from, and they were so helpful in guiding me to pick the perfect blinds for my home. It's no surprise that 3-Day Blinds has been in business for over 45 years and is the highest rated blinds company on Trustpilot at 4.7 out of 5 stars. Right now, you could get 3-Day Blinds buy one, get one 50% off deal on custom blinds, shades, shutters, and drapery. For a free, no charge, no obligation consultation, just head to 3dayblinds.com/Meidas. That's buy one, get one 50% off when you head to 3dayblinds.com/Meidas. One last time, that's the number 3, dayblinds.com/Meidas.
And here, Ketanji Brown Jackson, Justice Jackson, I think really lays it out here and says, if the most powerful person in the world can get away with anything, isn't that the most anti-American concept? Like, wasn't our entire country founded on a rejection of that principle? Watch this brilliant argument by Justice Ketanji Brown Jackson. Here, play this clip.
Okay, thank you.
Justice Jackson?
So I think I now understand better your position. In your discussions with Justice Kavanaugh, it became clear that you are saying that for the private acts of a president, there's no immunity, but for the official acts of the president, there is immunity. Is that your position?
I agree with that.
All right. So one thing that occurs to me is that this sort of difficult line drawing problem that we're having with all of these hypotheticals, is this a private act or a public act, is being necessitated by that assumption. Because of course, if official acts didn't get absolute immunity, then it wouldn't matter. We wouldn't have to identify which are private and which are public, correct?
That, in fact, is the approach of the D.C. Circuit. There's no determination that needs to be made.
Right, but I'm just making, so to the extent we're worried about, like, how do we figure out whether it's private or public, we have to understand that we're only doing that because of an underlying assumption that the public acts get immunity. So let me explore that assumption. Why is it, as a matter of theory, and I'm hoping you can sort of zoom way out here, that the president would not be required to follow the law when he is performing his official acts? Everyone else, there are lots of folks who have very high-powered jobs, who make a lot of consequential decisions, and they do so against the backdrop of potential criminal prosecution if they should break the law in that capacity. And we understand and we know, as a matter of fact, that the President of the United States has the best lawyers in the world. When he's making a decision, he can consult with pretty much anybody as to whether or not this thing is criminal or not. So why would we have a situation in which we would say that the president should be making official acts without any responsibility for following the law?
I respectfully disagree with that characterization. The president absolutely does have responsibility. He absolutely is required to follow the law in all of his official acts. But the remedy for that is the question: could he be subject to personal vulnerability, sent to prison for making a bad decision after he leaves office?
But other people who have consequential jobs and who are required to follow the law make those determinations against the backdrop of that same kind of risk. So what is it about the president? I mean, I've heard you say it's because the president has to be able to act boldly, make kind of consequential decisions. I mean, sure, but again, there are lots of people who have to make life and death kinds of decisions, and yet they still have to follow the law. And if they don't, they could be sent to prison, et cetera, et cetera. So
I say two things in response to that,
Yes.
both from Fitzgerald. That's the very sort of inference or reasoning that this court rejected in Fitzgerald.
No, but let me just, Fitzgerald was a civil situation in which the president actually was in a different position than other people because of the nature of his job, the high profile nature, and the fact that he touches so many different things. When you're talking about private civil liability, anybody on the street can sue him. We could see that the president was sort of different than the ordinary person when you say, should he be immune from civil liability from anybody who wants to sue him? But when we're talking about criminal liability, I don't understand how the president stands in any different position with respect to the need to follow the law as he's doing his job than anyone else.
He is required to follow the law. And what Fitzgerald
But he's not
said is
if there's no criminal prosecution. If there's no threat of criminal prosecution, what prevents the president from just doing whatever he wants?
all the structural checks that are identified in Fitzgerald and a whole series of this court's cases that go back to Martin Martin against Mott, for example, impeachment, oversight by Congress, public oversight. There's a long series that Fitzgerald directly addresses this in the civil context, and we think that language naturally ports.
I'm not sure that's much of a backstop, and what I'm, I guess, more worried about, you seem to be worried about the president being chilled. I think that we would have a really significant opposite problem if the president wasn't chilled. If someone with those kinds of powers, the most powerful person in the world, with the greatest amount of authority, could go into office knowing that there would be no potential penalty for committing crimes. I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
I don't think there's any allegation of that in this case. And what George Washington said is, what Benjamin Franklin said is, we view the prosecution of a chief executive as something that everybody cried out against as unconstitutional. And what George Washington said is, we're worried about factional strife, which will.
No, I'm also, let me put this worry on the table. If the potential for criminal liability is taken off the table, wouldn't there be a significant risk that future presidents would be emboldened to commit crimes with abandon while they're in office? It's right now the fact that we're having this debate because OLC has said that presidents might be prosecuted. Presidents from the beginning of time have understood that that's a possibility. That might be what has kept this office from turning into the kind of crime center that I'm envisioning. But once we say no criminal liability, Mr. President, you can do whatever you want, I'm worried that we would have a worse problem than the problem of the president feeling constrained to follow the law while he's in office.
Yeah, I respect.
And folks, that gets to the heart of the matter for me. You know, we can talk about complex legal doctrines, and you could watch Donald Trump's lawyer trying to, make comments about, well, there are structural safeguards in place. It's just a bunch of word salad. Are we a nation of laws? Are we a country of law and order? Are we a country where no one is above the law? How was our country founded? This is simple stuff. I like how Donald Trump's lawyer goes, well, there was a conversation where Benjamin Franklin once said this, and there was another conversation where Benjamin Franklin was speaking to this person. And are you aware that in page 22 of George Washington's diary, that George Washington had mentions, look, basic history. The United States of America was founded on the concept of we the people, not the king. We were founded on the rejection of absolute immunity. It's very simple. A rejection of the arbitrary and limitless power of kings. That's what our country was founded on, and that's why our country had been a beacon for the rest of the world. Donald Trump has spent his life breaking things. Donald Trump has spent his life destroying things. And his final act is to destroy our Constitution, to destroy the presidency, to destroy common sense. The case is now with the United States Supreme Court. We'll see what they do, but I hope showing you what Donald Trump's lawyer said, just you hearing it on your own, crystallized for you at the very least what's at stake. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. Let's get to 3 million subscribers together. Thanks for watching. Hit subscribe right now.
Enough! Send him to the big house, not the White House. Get the new exclusive tees, mugs, and stickers right now at store.MeidasTouch.com. That's store.MeidasTouch.com.